There are new rules for businesses, and you need to take action now. In this presentation, I'm going to cover changes for businesses that work with personal data. If you need to continue to receive personal data from the European Union for business use, you may need to take action on data protection. For the existing legal framework, your business needs to know that the EU General Data Protection Regulation, known as GDPR, requires organisations to be accountable for the personal data which they hold. Personal data is classified as any information that can be used to identify a living person, including their names, their addresses, and HR details, such as payroll details. GDPR has been retained in UK law after the end of the transition period, alongside the Data Protection Act 2018. For international data transfers, your business needs to know the EU-UK Trade and Cooperation Agreement contains a bridging mechanism that allows the continued free flow of personal data from the EU European Economic Area to the UK after the transition period for up to 6 months. The EU has an established way of allowing the unrestricted transfer of personal data to countries outside the EU, called adequacy decisions. An EU adequacy decision for the UK would allow for the ongoing free flow of data from the European Economic Area to the UK. Where the European Commission recognises that a third country's data protection regime provides adequate protection, personal data is allowed to flow freely between the European Economic Area, which includes the EU, and the third country. The UK is working constructively with the EU to secure an adequacy decision under the GDPR and the Law Enforcement Directive. As a sensible precaution, before and during the bridging mechanism, it is recommended that you take the following steps. You must take stock of the personal data you hold. We recommend that you work with EU EEA organisations who transfer personal data to you to put in place alternative transfer mechanisms to safeguard against any interruption to the free flow of personal data from the EU to the UK. You can put in place safeguards by incorporating standard contractual clauses. Further information can be found by searching for Keep Data Flowing on the Information Commissioner's Office website. Your business will need to prepare for any new rules around personal data. EU data protection law has been converted into UK domestic law with some minor technical amendments to ensure it is operable in the UK. UK and EU data protection law is therefore aligned. UK organisations may not need to do anything differently immediately to accommodate the withdrawal agreement requirements. In practice, you may want to consider, where possible, taking stock of the personal data you hold so you can identify and track relevant legacy personal data to which EU data law applies in line with the withdrawal agreement requirements. You should work with EU EEA organisations who transfer personal data to you to put in place alternative transfer mechanisms. For most organisations, the most relevant of these will be the standard contractual clauses, known as SCCs. More detailed guidance is provided by the Information Commissioner's Office on what actions might be necessary, and the ICO also provides an interactive tool allowing businesses to build SCCs. For further information, guidance is available online by searching for Using Personal Data from 2021 on the gov.uk website. Alternatively, you can use the QR code on this slide to access this information, or visit the ICO website for guidance or telephone the ICO helpline on 0303 123 1113. That's 0303 123 1113. New rules are here, and you need to take action now so that your business can comply with the new regulations.